Hi, this is Professor Pope, and this is a short narrated PowerPoint presentation on voluntarily stopping eating and drinking. So let's start with the definition of VSED, VSED. So this is a recognized means or method of hastening death. And it has these basic distinctive features, which is the patient is able to take food and fluid by mouth. So this isn't the same thing, and it is different from the situation where the patient is close to death and just has stopped taking food and fluid by mouth because of how advanced the illness is. They are able to, but are just making a conscious and deliberate decision not to. And when they make this decision, death will result from dehydration in 7 to 14 days. And so it is an important physiological fact of this method that the cessation of fluids be nearly complete, except for some small amounts, perhaps like a spray or ice cube, to alleviate symptoms, but not really any volumetric relief of thirst. So there are multiple terms. The leading term, and the one that I'll use, and that's used in most of the bioethical and medical literature, is VSED, VSED, voluntarily stopping eating and drinking. Another one that's been used is voluntary refusal of food and fluid. And then less common are some others, such as patient refusal of nutrition and hydration, stopping eating and drinking, or voluntary terminal dehydration. But this is all the same concept, so these are just variations in terminology. And so that's the basic definition. Here again, why use it, right? Why is this relevant? And this is not totally dissimilar from the discussions that we already had about medical aid in dying and some other means and methods of hastening death, right? One reason would be physical suffering that the patient is experiencing. This could be pain, it could be nausea, shortness of breath, paralysis, or foul swelling wounds. But as we saw with the data, robust data from 2 decades from Oregon and Washington, perhaps a more significant feature or reason to hasten death in general would be not physical suffering, but existential suffering. And so here, this might include psychic pain, a loss of control, anxiety, delirium, and hopelessness. And just to step back from that, in a nutshell, the real reason is that in the patient's own estimation, right, in her own judgment, looking at the quality of her life, she judges herself that the burdens of her life outweigh the benefits, right? And it's her life to live, and that's the judgment and trade-off and balance that she makes. And so it's important to say nobody is forcing this on anybody else. This is a question of the patient's own self-defined quality of life, right? And so the circumstances under which VSED might be employed is due to a decision that is based on the patient's own assessment, her own values, and her own preferences. There are a number of exit options, and we talked about most or all of these in the course at other points. And just to recap, and this is in a series of articles over probably more than the last decade by Tim Quill, who sort of summarizes and gives these nice overviews of the various what he calls exit options. In terms of decreasing order of acceptability, meaning from the most accepted and well-grounded in the law and in ethical justifiability down to the least, it would probably look something like the following, right? Where since the 70s, right, since the Quinlan case, and especially since the early 1980s, right, it's really been accepted in the Supreme Courts of every state, the legislation of every state, as well as in institutional policies and in practice, that if the patient wants to stop life-sustaining medical treatment, whether that's dialysis, mechanical ventilation, antibiotics, artificial nutrition, hydration, or CPR, that's fine. She has that right. Also, if the patient is experiencing symptoms, pain, that we can increase the dosage of opioids, even though we know that might hasten death because by reducing respiration, but that's okay because of the doctrine of double effect. We're not intending to cause death. We are intending to treat the pain. This is just a side effect of a known side effect, but a side effect of that. And you might say that the VSED, what we're going to talk about, is third, right in the middle here in terms of the order of acceptability. And perhaps more contentious than that is palliative sedation to unconsciousness, physician aid in dying, and euthanasia, which we might distinguish from physician aid in dying in the sense that in euthanasia, it is the physician who takes the final overt act that causes the death, so an injection of lethal substance, as opposed to the patient's own self-ingestion of the lethal substance in physician aid in dying. And so at the very bottom, euthanasia not accepted at all in the United States, legally or in practice. And of course, as we talked about last week, physician aid in dying, just 5 out of 50 states have accepted it so far. Okay, so the main thing to mention here about VSED is it has sort of a bad reputation in the popular mind, in the mind of the public. And here I think is the reason. When you have very high-profile advocates for aid in dying, and aid in dying for the last several years has been getting a amazing amount of attention, right, in the state houses, in the media, and so forth. And when the advocates speak on and make the case for why we need to have a law, like Oregon, Washington, Vermont, or California, they say, well, because otherwise our choice would be we have to dehydrate to death. And so VSED is often used as a foil to help make the case for why medical aid in dying needs to be legalized. And I think it's not completely fair to frame it as such a terrible, terrible way to hasten one's death, but I think it's used for political purposes to make it look like medical aid. The importance of legalizing medical aid in dying is more important, more urgent than it really is, by framing the alternatives as unacceptable. Right? If the alternatives, i.e., VSED, were perceived to be more acceptable, the need to legalize medical aid in dying would be less. Anyway, so these are just like this is Tony Nicholson. This is one of the plaintiffs from the New Mexico case, and the reason I mention these is because I could point out almost all of the leading advocates, whether advocates in a court case as Nicholson and this woman, or I could point it in the media, but case after case after case, VSED is sort of thrown under the bus in order to make the case for medical aid in dying. This week, in February, early February 2016, Diane Rehm, a very popular NPR host, came out with a book which paints VSED to be a very poor way to die, and yet, and she has used that to make the case for why she's an advocate for legalizing medical aid in dying. Anyway, so and in fact, maybe not every case of VSED is perfect, but it does seem that the advocacy machine for medical aid in dying has unfairly portrayed VSED. And to some degree, it's analogized to dehydration and starvation, which is analogized to military camps, whether those were from Nazi Germany or from China or other places during World War II and other wars. But of course, in those situations, the dehydration was not voluntary. It was not complete, right? So they still consumed small amounts of water. So it wasn't a process that led to death in a timely fashion, and it wasn't controlled. In contrast, all the reports, and admittedly, the literature is not super robust here. So this is not as well studied as it could be, but the reports that there are in the medical literature that studied this show that VSED is both a peaceful and comfortable way to hasten one's death. Even, and it's worth noting, of course, that if you go back to the earlier part of the class, even clinically assisted nutrition and hydration is still treated specially from other forms of life-sustaining medical treatment, like a mechanical ventilator. So if we even treat clinically assisted nutrition and hydration specially, then we're sure going to treat oral nutrition and hydration specially. So there definitely is some extra challenges with getting this means of hastening death accepted. And of course, remember the Terry Schiavo case, right? That it doesn't play well with people's moral intuitions that this is a legitimate and acceptable way to die, even if it was self-chosen by the patient. So just to recap, there is some evidence of safety. It could be better. There's one study. There's this study from Oregon, actually, where they compared, where at the time of the study, medical aid in dying was legal. And so some people, even though they had that option, chose VSED instead. So even when you have both options of hastening your death, some people voluntarily and deliberately choose VSED, and they report that those patients had a good death. This has been used for thousands of years by the Jain religion in India, so it's not a new technological sort of mechanism that we've invented to hasten death. So there's a tradition of doing that, at least among this one population. And there are probably dozens and dozens of anecdotal reports, and I agree that's not necessarily science, but it's worth mentioning that they're out there. So there are people like Michael Miller, who was a physician, who made a video about his decision to VSED. So these are people who wanted to share their experience. Phyllis Schachter had done a TED video about her husband's use of VSED and has just came out with her own book, has a website. So there are people who, and dozens and dozens of newspaper stories, magazine stories, profiling people who've done this. They interviewed all the family. And so it's gotten some exposure. It's just that these aren't at all randomized controlled studies by any means. Now, there are some legal concerns with VSED, and we can break those into two pieces. There's the VSED that's undertaken by a patient with capacity, right? So this would be parallel to medical aid in dying, where the patient with capacity herself makes the decision. And then you have the other situation where the patient isn't choosing VSED to happen now, but is like leaving instructions in advance directive that the VSED be implemented at some point in the future. This is something that you can't do now with medical aid in dying, but arguably you can do with VSED. So to take the situation with the patient with capacity who requests VSED right now, that's generally accepted and done across the country, and has been done across the country. I wrote about this in the Widener-Large article piece, trying to just basically give the snapshot of why that's a right of the patient and why that should be respected. In a nutshell, to force feed somebody would be a battery, right? Again, the general right is a right to refuse, right? This is the contrast that we talked about between refusing life-sustaining treatment and medical aid in dying. Is one is passive and one is active, and in general, you have the right of bodily integrity and to refuse somebody else putting stuff into your body. And that's what this is. So this looks a lot like being intubated, CPR. You're allowed to say, I don't want you to do stuff to me. I'm not asking for affirmative help like with medical aid in dying. This is just a passive refusal. It's just a passive refusal of water instead of some form of medical intervention. Some people say that it's assisted suicide, but again, that is normally referring to an active lethal agent, whether carbon monoxide, a bullet, a lethal dose of barbiturates. Here, there's no lethal agent that's being introduced to cause the death. It's just the passive refusal of something that was going to sustain life. So we have this active-passive distinction. That's why the Supreme Court denied finding a constitutional right to medical aid in dying, because they found that this distinction has meaning. You have a right, you have a passive right to passive euthanasia, but you don't have a right to active euthanasia. Okay, fine. Not everybody agrees that this is a coherent distinction, but it's accepted in law and policy in U.S. healthcare. And if so, VSED clearly falls in the passive side, which is the accepted and legitimate side of this distinction. Interestingly, there's a great quote from the 1997 U.S. Supreme Court case on legalizing medical aid in dying, which is Justice Rehnquist, who Chief Justice at the time, asked why it doesn't seem right that the doctor doesn't have a right to stick a needle in the patient's arm without consent. So why do they have a right to stick a spoon in her mouth? Another legal concern is that VSED constitutes abuse and neglect. And this is a significant concern, to be fair. In fact, if you look across at nursing home complaints, right, there is a high incidence of abuse and neglect. So patients are neglected, they get bed sores, patients are neglected, they're not fed enough, so their nutrition and hydration levels aren't adequate, because maybe the certified nursing aide isn't taking the time to really hand feed the resident. So that's true. That really happens. But it's important to, and so therefore, VSED looks like dehydration. So it looks like the nursing home is complicit in the very thing that they're getting in trouble for, that they're getting fined for. But that really shouldn't be a concern, because this is very different. This is a voluntary, informed, consensual agreement to participate in VSED, right? And so the patient is saying, yes, I am terminally ill and I'm suffering these symptoms and I want to hasten my death. And so the patient's consent really makes all the difference. And therefore, it really isn't neglect or abuse when the patient dehydrates to death, when that's what they've chosen to do. Okay, so the more complicated situation is advanced VSED. So the patient today has capacity and decides, look, in the future, when my dementia, it's not always dementia, but that would be the main category for this. When my dementia gets more advanced and I don't recognize my family and I can't really speak and interact with the world in a meaningful way, and basically the things that I find meaningful and enjoyable about life go away, that's not a state of life that I want to continue to have. Even if I'm still biologically alive at that point, everything that makes my life meaningful won't be a part of that biological life. So when I get to that point, the person says, now, when I get to that point later, don't feed me, don't give me a drink. So leaving instructions now to be executed later. Last year, about a year ago, almost exactly, this was written up in the New York Times about an advanced decision for VSED in your advanced directive. And so this is a little bit trickier than the contemporaneous decision by a capacitated patient. Just like in general, healthcare decisions in advance are a little bit trickier than contemporaneous decisions by capacitated patients. So again, the idea is that you leave clear written instructions for your caretakers, whether that's hospice at home or in a facility setting, to not feed and give you something to drink. This was tested in a case which I posted for you, because there actually aren't that many cases on VSED, but it's a very recent case. And so in this case, this is a woman who left clear instructions that if she got to a state of advanced dementia, she did not want to be fed. She got to that stage, stage 7 Alzheimer's, and her family wanted to honor her preferences and wishes, and said to the facility where she was a resident, stop feeding her. This is the time, these are her wishes. The facility refused to do that, and the case went to court. And so there's a lot of technical questions about whether the advanced directive was technically specific enough, and perhaps it wasn't, right? And so one lesson perhaps from the case is that if you want to have advanced VSED, be very, very clear and explicit, because it's going to be scrutinized, and therefore you want to be very clear that that's what you wanted and when you wanted it. But the more significant thing in the case is the fact that the court found that she had capacity to now, right? Today she has capacity. And that seems odd because she's stage 7 Alzheimer's. So she's basically completely non-communicative, doesn't really open her eyes, doesn't talk. So how is it that she has capacity, right? What does the word capacity mean? The ability to understand and communicate a healthcare decision. Well, right, as you saw in the case, she does have the ability to, when the spoon is put in her mouth, to swallow or to not swallow what's put in her mouth, or to open her mouth and to not open her mouth. So it's a very minimal level of interaction with the world, right? The attendant puts the spoon in. She either opens or doesn't open. She either swallows or doesn't swallow. But that's some responsiveness to external stimuli in her world. And remember, capacity is a decision-specific thing. And so while she doesn't have the capacity to do almost anything, the court held she does have the capacity to make a decision about whether to eat or not. And since she opens her mouth and since she swallows, she is telling us that she wants to eat. And therefore, her current consent, which she has the capacity to give, at least consent to this, constitutes a revocation of her prior instructions to not feed her now. And the reason this is significant, of course, is that if that level of responsiveness is sufficient to override or revocate prior instructions, then that doesn't bode well for the ability to leave advanced VSED instructions, because your later self, your later demented self, may feel thirsty. And therefore, when you express that feeling of thirst to your care providers, they interpret that to be, well, she wants something to drink. She told us before she didn't, but now she's telling us she does.